You were on bond for a theft case, and now you picked up another theft case. You now stand charged yet again with another theft. You're facing another 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 7th, 2025, the complainant observed the defendant trying on sunglasses in their store in the Galleria Mall. And after the defendant left the store, the complainant noticed the sunglasses were missing. The complainant then reviewed surveillance in which he was able to see the defendant putting the sunglasses in his front right pocket and leaving the store passing all points of sale. The complainant then flagged down an officer who was able to locate and detain the defendant.
Whoa, right from the jump, this judge isn't holding back. Bond revoked on a theft? That's serious. Quick poll. Do you think repeat offenders should lose all shot at bail, or should the system give more chances?
The defendant was wearing the sunglasses on his face and admitted to concealing them. The sunglasses were valued at $350.
Mr. Taylor, I'm going to find that there's probable cause to go forward with your case. I am now revoking your bond on the first case. Goes with you. Unacceptable. We will not continue to give you PR bonds. This is your third one. No more. I will appoint you a lawyer today, but you're staying with me. No going to the Galleria at all. Was the prior theft at the Galleria as well?
It was at a CVS, Your Honor.
Okay. No going to any CVS's, and I don't want you at the Houston Galleria. Do you understand?
Sure.
If I find that I don't know if you're going to get out. You get out, you pick up a third case, I'm going to go absolutely nuts on the bond. Do you understand? Goes with you. Good morning, Mr. Guzman.
Morning.
How's jail?
Same as always. Cold.
You're here with your lawyer. Your lawyer's on Zoom. I don't know, the TV's not working, but he's here with you. We have appointed Mr. Duong to represent you. You are on probation in this court for driving while intoxicated. Can you just put that right there in front of him, please? Right there. You recognize that?
Yeah.
Okay. We're going to do probable cause. I'd like to know what happened on so what happened is you're on deferred in this court for the DWI. You picked up a felony possession of a controlled substance. You also picked up an unlawful carrying of a weapon. I have no idea what happened on those cases, so I'm like to hear what happened.
Yes, Judge. On February 11th, 2024, the officer observed a silver Chevy Silverado traveling on the 2400 block of Little York Road in Houston. The officer ran the vehicle and it returned as a white Chevy pickup truck, and the officer knew that the truck in front of him was not white in color. Therefore, the officer...
Notice here, $350 sunglasses just escalated this guy's whole future. Sometimes it's not about the value of the item, but the pattern of behavior. That's what judges hammer.
Initiated a traffic stop. The defendant immediately opened the door and attempted to get out. A high-risk stop was initiated, and the defendant complied with instructions. The defendant was detained, and the officer observed an NL sticker on the vehicle, which the officer knows stands for Mexican State of Nuevo Leon. The officer observed in plain view a glass pipe connected to a plastic bottle from which training experience known to be consistent with drug paraphernalia. The officer located a clear crystal-like substance consistent with meth, and another officer located a handgun behind the passenger seat.
Notice how the judge zeroes in on both the drug possession and the firearm charge? That combination is extremely serious in Texas courts. When drugs and guns show up together, prosecutors often push hard for harsher penalties. What do you think? Should possession plus a weapon automatically mean tougher consequences?
I'm sorry, you picked up with us the unlawful carrying of a weapon. I'm going to find that there's probable cause to go forward with your case. So, John, it looks like felony court is set for the 17th. Do you want to set it perhaps for the day after to see what happens up there?
Sounds good to me, Judge. And then I'll, Mr. Guzman, I'll come by the jail to talk to you further. Okay?
Okay.
I'm ordering you as a condition of your bond on both cases not to drive any vehicle whatsoever for any reason. And they gave you a PR bond on your gun case. I don't know if that was a smart move. You've not made bond on the DWI as it is, so I don't know. We'll see about the PR bond. But do not drive. I don't know if you're going to get out or not. If you do, you will get a GPS monitor because you are a flight risk. I find by clear and convincing evidence that you are a flight risk. As a result, you will get a GPS monitor, and I'm also going to give you a curfew from 7 p.m. to 7 a.m. Do you understand? You are not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using, likewise, you will go back in.
I haven't. You want to drink this?
Well, I can't while you're in jail.
Okay.
But if you do get out, trust me, Mr. Guzman, you will be tested frequently.
Okay, that's fine with me. I haven't been using drugs.
So what I'd like to do also is do a TRAS to see where we go from here. I don't know, quite frankly, I don't know where we go from here. You're on probation in this.
Drugs and a firearm? That's a deadly combo in the eyes of the law. In Texas especially, prosecutors love stacking these charges. Should carrying while using automatically mean jail time? Drop your thoughts.
Court, and I don't know, because what we typically do is we do evaluations to see, because I have clinician on staff to see how we go forward. I know you tell me what, it's like little bunnies jumping in the woods, but the fact remains is that you've picked up a new case, you absconded on our case, we had issues with that, now we've got issues here of what happened with these cases, so we will have you evaluated to see how we go forward. And I don't know, they may say residential treatment, they may say outpatient treatment. I have no idea, but that's why I have clinicians on staff, because they are better. They have the tools to tell me how to go forward, because Mr. Guzman, I just don't know you.
I'm just trying to get rid of this stuff and get it over with. I don't want to be up in here as much as you want to see me up in here.
So, if you don't mind setting them up for a TRAS, and then we'll go from there. So, John.
The reset date was 3/17, Judge?
No, he's set for February 17th, so next.
Okay, I gotcha. So he's going
On Monday, he's set for felony court, so I guess we'll do, the next day, and we'll figure out where we go, huh?
Yeah, I'll have to zoom in, Judge, because I'm out for the rest of next week.
Okay, no issue, no problem, that's where we have it, okay?
So the 18th?
Yes.
Yeah, okay. Gotcha.
Okay.
All right, Judge. Thanks.
And boom, GPS monitor, curfew, random testing. The judge is basically saying, we're letting you out, but we don't trust you one bit. Harsh or fair? You decide.
All right, Guzman, I'll talk to you.
So do you mind those conditions, please? And we'll have him sign it. All right, man.
All right, thank you, Judge. Have a good weekend, man. Excuse me.
You too, man. Happy Valentine's Day.
You too.
So you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On August 1st, 2024, the officer was dispatched to a disturbance call, and upon arrival, the complainant and security staff stated that the defendant made threats to kill everyone, broke 2 hospital monitors, and was acting aggressive towards the medical staff. The complainant stated the medical staff became scared since the defendant stated, "I will kill you all." The complainant stated she was scared for her life since she did not know what the defendant would do next at that moment.
That doesn't sound right, because I didn't do that.
We'll give you a lawyer, and we can go through this with the lawyer. So, did he direct it at a person? Is he directing at the entire world? But
the statement was only made that, "I will kill you all." And it says the complainant stated the medical staff became scared, and the statement was that, "I will kill you all." That's all we have from the DMs, Your Honor. And then furthermore, the complainant did state she was the only one at the hospital at the time of the officer's arrival, since the rest of the medical staff had gone through a shift change and she was the only one there. So it's not exactly clear who was there when the statement was made. He just said, "I will kill you all."
all right, so who's it directed to? Just
I don't even know that.
The DIMS does state that the defendant started to act aggressive towards the medical staff.
And
So
I think that's why she was scared, right?
it appears that it could follow on saying the defendant was, the complainant said she was scared and the medical staff was scared since he stated, "I will kill you all." So it appears that it was directed towards the medical staff as he was acting aggressive towards the medical staff.
That's tough, curfew and GPS monitoring on top of bond conditions. The judge is clearly worried this guy won't show up. Quick question for you. Do you think strict conditions like this actually keep defendants accountable, or just set them up to fail?
Appears.
Because there's just two distinct
Hunch.
There's two distinct sentences, Your Honor, where he acted aggressive towards the medical staff, and the complainant stated the medical staff became scared since the defendant stated, "I will kill you all."
I thought he did time for that too.
Mr. Mickish, I'm going to find that there's no probable cause to go forward with your case, but you need to be careful.
So,
Scaring people can kind of hurt them. You know what I mean?
Your Honor, I don't.
Look, don't. Mr. Mickish, patience goes a long way.
Yeah.
You know, when you get upset and when you lose control, that's why we have so many people in jail, because they lose control, they do whatever they want to do, and they don't think, if I do this, what's going to happen? If I say this, what's going to happen? Be careful, all right? All right, just hang tight for me with that. All right, Ms. Fernandez, you have been given 2 PR bonds, and your case is nearly 250 days old. They are still allowing you to take this plea bargain agreement where if you complete a class, your case will be dismissed. They are giving you only until Monday. So what we will do is we will reset your case until then. If it's not done, we will have to go another route. If you ever miss court again, you will not get any more PR bonds. That will be the 3rd time that you have failed to appear for court, and it will not go well. Do you understand? You have a lawyer. It is your responsibility to stay in touch with the lawyer, and they can always get a hold of us. But there's no excuse. No tolerance anymore. Okay? Good luck.
Thank you.
You are charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Yes, Judge. On February 9th, 2025, the officer was dispatched to an assist the officer call in regards to a shots fired at 1700 Travis Street. The defendant was detained because the officer observed an unidentified individual discharge a firearm, and the defendant was within that group of people. The defendant admitted to the officer that he had 2 ecstasy pills in his right front pocket and that there was an AR pistol in the SUV the defendant was driving. The officer completed a search of the defendant and located 2 methamphetamine pills in his front right pocket, and the defendant informed the officer that he was aware of the AR pistol in the SUV prior to him getting behind the wheel. The officer located the AR pistol on the floor in the 2nd row of the SUV within reach of the driver. The substance was believed to be methamphetamine based on training experience with a weight of 0.61 grams.
Husband, I'm going to find that there's probable cause. Wait a second. He says that the AR is his?
He says he was aware that it was in the vehicle and it was within his reach in the vehicle.
Whose vehicle is it?
I don't believe it says in the DIMS, it says he was driving the vehicle.
How do you put it on him?
Allow me to read the full DIMS, Your Honor. Yes, Your Honor. It says that he was driving, so it would be that he was in care custody control because he was operating the vehicle with knowledge that the firearm was in there and it was within his reach, his ability to grab the firearm.
Diego Camacho?
Not. How do we know that how do we know that it was in there while he was driving? How do we know that they didn't put it in there after the fact?
The defendant stated that he was aware that the AR pistol was in the vehicle before he got into the driver's seat, before he started driving.
No. It just said that he was aware. Don't add stuff in.
I'll read the complete DIM.
Read it.
It says, the DIM states completely that the defendant informed the affiant, the officer, he was aware the AR pistol was in the SUV prior to him getting behind the wheel, and the defendant informed the officer that the AR pistol could be found in the SUV at the time of his arrest.
Are we to assume that it's his? All he says that he knew that it was in there. You know, it's not his car.
In Your Honor, just as cited, the pleading is that it was on or about his person. So we're just saying he was in his possession because it was in the vehicle he was operating with knowledge that the AR was in the vehicle as well as it being within
Do you
our.
even know when he was operating the vehicle?
I apologize. What do you mean when he was operating?
Was he operating it in the morning, in the afternoon, at 9 o'clock at night? When did all this transpire? What time of day is this?
Let me see, Your Honor, because based on the DIMS that I see, it appears that
There's a group of people.
it appears that the defendant was, according to the DIMS, the defendant was found to be at the wheel of a black GMC. So when the officer arrived, he was observed within the vehicle, from what the officer says.
Was in the car at the time the cops get there.
From what the officer says, that he was observed behind the wheel of the vehicle. To be at the wheel of the black GMC Suburban bearing a license plate number that is in the DIMS. So it,
Okay. All right. Mr. Husband, I'm going to find that there's probable cause to go forward with your case. I mean, we take it seriously. I want to make sure if there's enough probable cause that that's, you know. So I am ordering you as a condition of your bond not to be in possession of weapons. Do you understand? If I find that you're a danger to my public, I only have one place for you. So don't. That includes everything. Do you understand, Mr. Husband? Do you mind filing no weapons, please?
Yes, Judge.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold.
Wow, case dismissed, but with a lecture on patience. That's a rare courtroom moment. You dodge jail time, but the judge basically says, control your temper or you'll be right back here. Classic reminder that in court, words alone can make or break your freedom.
Of you because you're ducking, you're dodging, you pick up a new case, it's not going to go well for you. You understand? All right, I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the jury box. I get your bond conditions. We'll have you sign it, and then you're free to go. All right? Mr. Williams, you were charged with assault of a family member. You were facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 8th, 2020.
Case dismissed, but with a catch. You lose your cool, you're back in. Think about that. Words alone can either save you or sink you. Courtroom discipline is everything.
5, the officers were dispatched to a disturbance call. The officer met with the complainant, who stated that she and the defendant were in a 7-month relationship. The complainant stated that she shoved the defendant with her shoulder and that the defendant then grabbed her and threw her around. The complainant advised that the defendant was grabbing her face and neck area and has pushed her to the ground, causing pain. The officer observed a laceration on the complainant's hand and a swollen lip. The officer made contact with the defendant, who stated that he lost control and that he admitted to shoving the complainant.
Mr. Williams, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person. Do you understand? If you have contact with this person, if I find that you're in possession of a weapon, I'm going to revoke your bond, put you in jail. No more PR bonds. I want my community safe. I don't care who it is, what color they are, whether they're a small farm animal, I don't care. Everyone gets protected. Do you understand? Do you have the ability to hire a lawyer, Mr. Williams? Okay. I will take a look at an affidavit. I'll see whether you qualify, and then I'll have you take a seat in the jury box. I'll have you sign a reset with Victoria now. Do not leave until you sign our bond conditions. Do you understand? And then I'll have you talk to a lawyer here momentarily.
I work with her, so
I'm sorry?
she worked at the same.
That's going to be an issue. I don't want you to have contact with her. Actions have consequences. Did you get appointed, Mr. Williams?
Yes, Your Honor.
Great. I wanted you to look at probable cause to see if you guys had any issues with it. That's why, or wait, no, maybe that was another case. Okay, tell me.
We were approaching, there's a MOEP and bond conditions that have no contact. The parties no longer live together, but they work at the same place, and there's a chance that their schedules could coincide with each other. State's okay with no threatening and harassing, but
Have you reached out to the complaining witness? Do you
Yes,
know?
so, I mean, she's not on board, regardless, but I confirmed that they don't live together, so my suggestion was to have no threatening or harassing, that way both of them can work.
But I want to make sure that she's, protected, that she doesn't have any kind of fear.
Yeah, she's She's not really concerned, from my understanding, but, I would suggest, just keeping the residency restriction so that, because they don't live together,
Mr. Williams, come up.
and then just, keep the no threatening or harassing contact for that purpose.
Good morning. So your lawyers asked for me to modify your bond conditions to say no threatening or harassing. I will acquiesce, but you have to understand what is threatening or harassing. Doesn't matter what you think, it's what she perceives. So if I'm going like this, is that threatening or harassing? It most certainly is, and it can get you in trouble. I don't know what kind of relationship you have with this person, but if it's a type where you're constantly butting heads, you got to be careful. There are many, many vindictive people in this world, and you never know if all they got to do is call, hey man, he's doing this, he's doing that, and then you're going to end up back. So you got to be careful. You understand? Okay. So the only thing I'm doing is I'm modifying the conditions, so no threatening or harassing contact. The residential restriction will still apply, so you cannot go to the house listed in the order for protection. Any more questions, anything?
No, Your Honor.
Okay, all right, good luck.
Judge, you want me to refile that, because I know the language that's typically in there.
Yeah, I would, just in case, so it's like nice and clean, yeah.
That's good, I'll file that now.
Thank you, Judge.
Oh, and no weapons too?
Yes, sir.
Okay. Mr. Camacho, you're charged with failure to stop and give information. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On February 7th, 2025, officers were dispatched to Hardy Road in Harris County, Texas, in regard to a minor crash, failure to stop and give information call. Upon arrival, the officer spoke with the complainant, who was also in police uniform. The complainant stated he was driving on the freeway when another vehicle got into his lane and cut him off to make the exit. The defendant got over and hit the front right panel of his truck with the back driver's side of the defendant's vehicle. The complainant followed the defendant, who had his hazards on, but the defendant did not pull over. The complainant continued to follow the defendant's vehicle until the 911 operator told him to stop following. The complainant gave a description of the defendant's vehicle, and a license plate number to the dispatcher. The complainant pulled over and waited for the officers to make a report with an estimated damage of $2,000. The officers ran the license plate and found the vehicle registered to an address on Skinner Road, and the officers traveled to the location and met with the defendant and his father. The officers were given consent to enter the property, look at the vehicle, and observe damage. The defendant stated he was crossing the lane to get over because there was an opening and that the truck accelerated and hit him. The defendant stated the complainant already hit him and was close behind him, so he kept going. The defendant stated he turned down his street and the complainant kept going. The defendant's address is approximately 7 miles from where the accident occurred.
Okay.
So, Judge, if I may, the complainant was only stopped following him while he had his hazards because he was told on the 911 call. And also, I see on the summary that when they run his license plates, is license plates GS9711 is missing a letter. License plates are usually 3 letters, 3 and 3 numbers. So I'm not sure how running the license plates will go to his house. And additionally, if the correct license plates were also run, then it would actually show that he's not the owner of the vehicle. So I'm not sure how they were able to identify.
Somehow they got to the house, right?
Yes, Judge, they ran and they got to an address and they went there and met with the defendant.
And then he states that he was driving, right, and the collision occurred, and then he took off. Your license plate, I have no idea. I mean, did they have the full license plate, or did they not?
Your Honor, at this time, I don't know. The DIMS just states, as counsel said, just GS9711. So I don't know in the full offense report if it says the full license plate number, but either way, they ran a license plate and they returned.
Somehow they were able to get it to him. I don't know. I mean, if you discover something later that's different, come back and we can revisit probable cause. I'm happy to do that at any time.
Yes, Judge. And so the reason I say that is because I have the tags for that vehicle, and that's not the license plates that they have on the summary. And that's
I mean, really, we'd have to set it for a formal hearing.
Okay, Judge.
Because I have to give them time to be able to respond to that as well, because that's more, I mean, this is just a mere probable cause hearing.
Your Honor, in the OR, there is the complete license plate. It's RSG and it continues on, so.
I'll check on that, yeah. That's good.
So you're saying it was in the DIMS?
In the DIMS, it was missing a letter, but in the full OR, they have the complete license number.
Pull the 911 tapes, see what the 911 tape
We'll wait
says,
for
right?
that,
It may
Judge.
be different, maybe they'll have the whole thing on the 911 tape, So, Mr. Camacho, I'm going to find that there's probable cause to go forward with your case. Have you run his license? See, he has a valid license.
Running, Your Honor.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand?
Yes, sir.
That is a condition of your bond. So if I find that you're driving and you don't have a license or you don't have insurance, I'm going to revoke your bond. I'll put you in jail. No more PR bonds.
Eligible, Your Honor.
You understand?
Yes, sir.
Okay, now you have a lawyer. Good job having a lawyer. Because you do, I will waive your appearance, but it is your responsibility to stay in touch with her. You don't have to come back to court. She'll let you know when you have to come back to court. All right? All right, I'm going to have you sign a receipt of Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Thanks. Yes, ma'am. We're Lauren Thompson. Ms. Thompson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you now.
One moment, Your Honor. It's Thompson, correct?
Oh, sorry.
Okay. Okay. On February 8th, 2025, the officers are traveling on 4300 Luella Avenue in Deer Park and observed a motor vehicle driving with an expired license plate. The officer confirmed with TCIC and CIC and performed a traffic stop. Upon making contact with the defendant, he observed bloodshot eyes, slurred speech, and a strong odor of an alcoholic beverage. The defendant admitted to consuming 3 alcoholic seltzers, and standard field sobriety tests were administered. HGN 6 out of 6. Walk and turn 8 out of 8, 1 leg stand 3 out of 4. The defendant was read the DIC and refused to provide a sample, and a blood search warrant was signed and executed.
All right, Ms. Thompson, I'm going to find that there's probable cause to go forward with your case. Any prior to WIs, and does she have a license?
No priors, Your Honor. I'm running her license right now.
She doesn't have any priors.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. As long as you're not using, everything will be fine. If I find that you're consuming alcohol, illegal drugs, I'm going to revoke your bond, put you in jail. Do you understand?
Your Honor, we'd like to state that she did tell the officer that she had taken some medication. So she did explain to the officer that she was under some medication. So we would like our concern is the revocation of her license. There's motions for.
I'm not revoking her license. I mean, you may continue to drive, just if it does become suspended at a later point, you just have to be cognizant of that it does, that you're not allowed to drive. So just be careful. I don't know what's going to happen with the ALR hearing and all that, so just be careful. Now, you have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with her, and she'll tell you if and when you have to come back to court. Just don't consume alcohol. Don't use illegal drugs. If you're taking, or no unprescribed controlled medication. If you're taking medication prescribed by a doctor, that's absolutely fine.
It's eligible, Your Honor.
Okay, just understand that if you're taking a controlled substance, even prescribed by a doctor, if you take too much, it can be an intoxicant, and if you get in a car, it's bad news. So you just be very, very careful. You understand?
Okay. Thank you, Your Honor.
I'm going to have you sign a receipt of Victoria. We'll have you sign your bond conditions for Fleischer, and then you guys are free to go. Thanks. That way.